Injury in Fact by Andrew Simeri. In this presentation, we will be covering injury in fact requirements, why some plaintiffs have standing and others do not. That will cover TransUnion versus Ramirez and Adias versus Carefree. Constitution of standing, substantiation, and concrete demonstrations of injury, and private company and government agency obligations for data breaches. Injury in fact requirements. Judicial power is extended to all U.S. cases that arise under the U.S. Constitution. A plaintiff must provide substantiated concrete evidence of injury in court. This is under Article 3, Section 2, Clause 2 of the United States Constitution, which defines injury in fact and decides whether or not a case can appear in a federal court. For a plaintiff to meet injury in fact requirements, they must provide substantiated concrete evidence of standing of physical injury and have a personal stake in the claim. This claim cannot be made by an outsider. Injury in fact requirements. The claim must be real, concrete evidence of injury or future risk of injury. The case will be held in the state of the violation. This claim cannot be theoretical and must have hard evidence proving to the courts that injury has or will be made in future. This case must also be held in the state where the physical injury occurred and must be protected by laws such as privacy law. Why some plaintiffs have standing and others do not. Plaintiff's evidence of injury must be substantiated in concrete. If the plaintiff does not have this, they will not have standing in the court and the trial will not be held. We will look at TransUnion versus Ramirez class action lawsuit and Adias versus Carefree Incorporated. TransUnion versus Ramirez. 8,185 individuals had filed suit against TransUnion LLC for mishandling individual credit reports and falsely reporting those reports to businesses. U.S. Supreme Court deemed that 1,853 of the class members had standing, being their information was mishandled and TransUnion failed to maintain accurate credit files under the FCRA, which is the Federal Credit Reporting Act. And the case moved forward with each member being paid out $7,337.30. The class action members had standing because they identified a violation that impacted them directly and was backed by the FCRA. Adias versus Care First. Adias and class members filed a suit against Care First due to 2014 data breach. They claimed that Care First was a breach of contract and had violations under the Consumer Protections Act in Virginia and Maryland. The plaintiffs could not determine whether all class members had suffered concrete injury due to this data breach. The court denied the motion because of their plaintiff could not provide the concrete evidence of substantial injury, but allowed the plaintiff to file for recertification in 2 months. This was due to lack of evidence that any of the class members had suffered identity theft or financial loss due to the breach or would suffer these. The difference between the TransUnion case and the Adias case is that the members of the class action were able to provide the evidence in the TransUnion case that they had suffered some sort of injury, whereas in the Adias versus Care First, they were not able to provide this, so they did not have standing, whereas the members of the class action for TransUnion did have standing. Constitution of standing, substantiation, and concrete demonstrations of injury. Substantiation is when a plaintiff has provided the court with the substantiated evidence of injury or future injury. Standing is only determined by court once the plaintiff has proven it has standing due to concrete injuries such as identity theft, financial loss, or fraud. These are just a few examples. Constitution of standing, substantiation, and concrete demonstration of injury. Concrete demonstration of injury is determined when a plaintiff has provided concrete evidence of injury. Evidence is backed by law, as in the FCRA, which is the Federal Credit Reporting Act, or the Consumer Protection Acts of Virginia and Maryland, as discussed in previous cases. Private company and government agency obligations for data breaches. Companies and government agencies are to provide effort to protect consumer interests. If they are not providing security measures to protect consumer data, they are subject to a lawsuit by the Federal Trade Commission under Section 5. They are also required to notify individuals if their personal identifiable information, PII, has been leaked in the breach. These notification laws vary by state, but should be immediate following the identification of the breach. For example, in Tennessee, consumers are required to be notified no later than 45 days following the identification of the breach. Works cited in references.